Hey guys, welcome to my channel. Okay, I want to just quickly do an update. John Deaton last night, he was live streaming with Jeremy Hogan about the library and the Ripple case. They were talking about Ripple versus SEC, the lawsuit update. So I'm going to share that with you today. Okay, enjoy and if you like it, I will upload more of these live streams for you. Okay, bye for now. Enjoy.
And we are live. Welcome to Cryptolaw TV. I'm John Deaton, the founder and your host. This week's continuation of coverage of the war against crypto, the United States government regulatory bodies and their war on crypto. And normally I give a bit of a speech and some things, but I have a special guest. I want to cut to the chase because I know a lot of people out there want to hear what he has to say a lot more than what I have to say. So bring on my dear friend and someone I respect greatly in the XRP community and loved, and that's Jeremy Hogan.
Hey, Jeremy. John, how's it going, man?
Pretty good. How's retirement, man?
It's been great. I put on a couple pounds. I've actually had a couple beers on a Saturday night. It's been amazing.
No, well, I can tell you the people tuning in now live and tuning in after this is recorded, they're hoping that this video gives you that itch. You know, I have an effect on people sometimes, right? They're hoping that the itch to come back and give us another Legal Briefs video happens soon. But
you never say never. Never say never.
Anyway, so this week, you know, we're every week, Jeremy, it seems like there's, you know, more and more news. Just literally today, we learn about the CFTC's case against Binance, where they're calling some of the assets commodities versus what the SEC does. We learned about the Coinbase receiving a Wells notice. I've been on record to say that I believe other exchanges probably received Wells notices as well. And just yesterday, we put on Cryptolaw, and I know that you commented the hearing transcript from November back in the LRBY case. And so I want to talk about that because you had a comment on it. I've been saying that we're not going to get regulatory clarity from Congress for a long time. And so the only kind of victories we can get are in the court. And so what's your opinion on that? And then what was your opinion on the LRBY?
Well, my opinion on the first issue you raised, which is the attack on crypto that's coming up from the U.S. government, is that it's really not a surprise. And I think that, you know, you've been talking about it for 2 years now. I've started talking about it about the same time. And this has been a choreographed attack. I think the surprise for me, maybe for you too, is that it's just been so obvious, like what they're doing. The U.S., the president came out with his report on the economy, which basically set aside 30 pages just to attack crypto. And I mean, Gensler's been just choreographing what this is going to be happening for the last year and a half. So this isn't really surprising. What's really more surprising to me is how blatant and open and obvious it's been that the U.S. government has decided just to attack a whole industry. It's nothing that I've ever been around or involved in before. So it's just taken me by surprise just how open and obvious they've done it. So, you know, it's no surprise this is happening. It's just a sad thing to see. And then go into Jeremy Kauffman and the LRBY hearing that Cryptolaw published the transcript the other day. You know, I read that, and really, it was, for me, it wasn't really a legal hearing. This was just, you know, to set the stage. The judge had already ruled that LRBY had sold the LRBY token as a security. So this was just a status hearing where the judge was saying, okay, guys, now what do we do? Are you going to be able to settle this, or what are we going to do from here? And the attorney started talking, and then Jeremy piped in. It's like, I just want to talk. And you could tell his attorney, he hadn't cleared that with his attorney. I think his attorney was like, uh-oh, I have a client who wants to talk to the judge, right? So the judge sets him in a different room, and the attorney says, well, if you want to talk, I can't tell you not to, but please be careful what you say. And then Jeremy comes back on, and actually I was just kind of sad when I read the transcript, because, you know, this brings it down to a very minute level where you have a guy that spent 5-6 years of his life working on this project, and it was just, you know, it was destroyed by a independent government agency. And so he's just kind of talking about how that made him feel and about all the frustrations he's had dealing with this government bureaucracy for the last 5 years. So that was how I felt. I didn't read it as a lawyer. I felt like, wow, this is sad that a business owner was put through this.
Well, let's let the audience see it. I think we can pull it up and people can see it for themselves. You have him saying they've been going back and forth with the SEC 5 years, just like you said it. And, you know, when you go through this, it really is an American entrepreneur, you know, basically saying that they offered that they will destroy the pre-mine in the company. And he just wants the same legal clarity as the other cryptocurrencies. And then what I want to ask you, though, if we go to the next page or the next part of the transcript, this is where Kaufman sort of speaks, you know, on his own outside of the presence of his lawyer. And what did you make of that scenario? As a lawyer, what would you have done? Let's put it that way. In that situation, would you have cringed or what?
Yeah, well, the emotion that comes to mind is embarrassment, because I think you've been there before when a case doesn't go the way it should go. Sometimes you go into court, right, John, and you try a case and you probably should lose, and you lose, and you're like, that's fine. But when the justice system fails, to me, I feel embarrassment, because we are part of the system. You know, Kaufman's attorney is a part of the system, you know, and I could argue either way in a case. So we're part of the system, and someone from outside the system, like a Jeremy Kaufman, looks at it and says, this is ridiculous that this happened. I feel embarrassment because I'm a part of that system. You know, for example, after everything that we've learned in the Ripple case, not to like change subject, but if the judge came down and just threw us a curveball and I don't know, ruled, I mean, Ripple could lose, but if she ruled on an issue that came out of left field that just doesn't seem reasonable and is ridiculous, I would feel kind of an embarrassment when I talk about it, because I'm a part of the system that failed us. And you can kind of see that. Let me just get to it in my transcript here, because he says he's really talking about the American judicial system, and now I've lost it, but he's trying to, you almost see that he's exasperated at this point, because he just can't believe that this is going to happen. Can we pull that back up? Maybe I could just look at it on here.
Yeah. Go back to go ahead.
The last part.
The second page. There we go.
Yeah, and like he says that, you know, these are simple questions. This is Kaufman talking. You know, if the rule of law is real, these are questions that are answerable. So why can't anyone tell me if that's legal? If the rule of law is clear and fair notice is a defense, because the average person can understand the law, then why can't the SEC attorneys answer a very simple question right here in front of you, Your Honor? And so that's just a final, like, I just can't believe that the court ruled this way. And you know, when the attorney in that case, I think you're feeling embarrassment, because you probably realize your client's right.
And what was striking, you can take it down, but what was striking was that the questions he was saying to the SEC in front of the judge was, okay, if I close the company down, LRBY, forever, if I close my bank accounts and give you all the money from our bank accounts, our business bank accounts, if I destroy all the pre-mine tokens, if I do all those things, therefore I'm out of business and I don't have any tokens, so I'm not aligned with any user out there, will you at least say now that it's not a security? And the final thing I want to talk about LRBY is, when you read that transcript, the judge kind of is sympathetic with Jeremy Kaufman, even though he kind of included the judge as being a part of the system that he's going against. And ultimately, the SEC said, we don't give that kind of advice. We're just not going to answer that question. And so what do you think? Do you think that, because you brought up the Ripple case, and a lot of the audience wants to know your opinion on everything Ripple, do you think that Judge Torres is aware of what's going on in the LRBY and everything that's happening? Do you think she reads the comments by the judge or or do you think, hey, that's another judge in another circuit I don't have to worry about it. What's your take on that?
So I don't think judges live in a vacuum. I think if an issue is a big enough issue, I think they realize that there's something important in here. And certainly when you have thousands of people listening to some, I don't want to say stupid, but some stupid hearing that we had a couple of years ago on some issue of discovery, and you have thousands of people listening in on it, that kind of cues the judges in that this is a big deal. The only other thing I can think of, because who knows what Judge Torres is or isn't doing, but the other thing that a lot of people haven't thought of is, these federal court judges have, I think, 2 law clerks. And law clerks are usually really smart kids that get out of law school and they go work for a judge for 2 or 3 years. They get to put that on their resume. It's a very good thing. They get hired at big law firms. They make a lot of money. But these would be guys or girls in their 20s, late 20s, maybe early 30s. And
great point.
You can't underestimate the amount of influence that the law clerk might or might not have on this case. So the judge would make the decision. But don't underestimate that a law clerk who's in their late 20s, maybe owns crypto, maybe their brother mines Bitcoin, could be doing the research and actually writing the opinion under the judge's guidance.
All right, we're going to talk a little more about Ripple case, but before we do that, I have to ask you, obviously the big news in the last couple of weeks, and it's something that, I hate to be the guy to say I told you so, but I did predict a year ago that exchanges, including Coinbase, would be sued because we have an out-of-control incumbent protecting megalomaniac as chairman of the SEC. Those are John Deaton's words, not Jeremy Hogan's. What do you make of the fact that Coinbase gets approval of an IPO in April of 2021, and literally before 2 years later, they're going to be sued by the SEC?
Well, there's only one way to look at that. I mean, it's ridiculous. The SEC will come back and say, well, it's not our job to look at your business model and approve or disapprove what you're doing. Our job is just to make sure that your S1 was filed properly, and we just, rubber stamp it, and that's our only job, which is a bunch of hogwash. I mean, if I'm going to IPO a business and I say in my S1, hey, my business is selling cocaine to high school students at the lunch cafeteria, that's not going to be approved. So I don't think that really flies with me. But that's the situation we're in with this independent agency of the government.
And I have to ask you, Jeremy, you're a fellow plaintiff's attorney like me. You represent people who are injured. You file lawsuits and things of that nature. And I just want your honest opinion, because I really do respect it. When back in the day with the Ripple case, and even in the LRBY case, when the SEC filed the case against the former product manager, and he listed 9 tokens and said they were securities, I said, hey, you should have did what I did and do a motion to intervene, try to come in as a defendant before the SEC can get its legs under it. That was sort of my theory. And of course, as you know, that's very contrary to what an in-house counsel would normally say. So what's your take on that? Do you agree with them that that's just a crazy thing, and that's why I'm never going to be a general counsel?
Yeah, well, I have represented a couple clients, and as kind of like a general counsel, and the mindset is different than as a litigator. So as a litigator, what you say is absolutely correct. But as a general counsel, your whole job is to keep your company out of litigation. So I kind of see it from both ways, and I kind of feel for in-house counsel, because that's their whole job is to keep you out of litigation. So it's hard for them to say to you, go ahead and get into litigation because it's coming anyway. But You're absolutely right. And of course, in hindsight, we know that's what they should have done, because now they're where they are.
Now, I went ahead and said that that Coinbase has fair notice 2.0 because of that IPO, because they went to the SEC. Even with the listing of XRP, as you know, Jeremy, in January of 2019, Coinbase went to the SEC. They literally gave them a presentation of why XRP was not a security, or at least today's XRP. They weren't discouraged at all. They listed it. And then, of course, the history. But do you agree with that? Do you think that this fair notice issue, and that's what Jeremy Kaufman, you read just a few minutes ago, where he said, apparently fair notice isn't a defense. Do you think Coinbase has an equally better or better fair notice defense than Ripple?
Good question. You know, I think when you get in front of a jury, I think the amount of time that's passed that someone has been doing something to when they get a Wells notice or a lawsuit is going to make a big difference. I'm sorry. So I think that Ripple has that time on their hands, because it really literally was, I mean, what, 7 or 8 years before there was any inkling that there was a problem. Coinbase doesn't quite have as much time on their hands, and also that the issues that Coinbase, it looks like they're going to be sued for, are a little bit different than what Ripple's being sued for. There's some more subtle and more legal technical issues, like, you know, how they were doing their stable coin staking and all that kind of stuff. So I think the short answer is I think Ripple has the better argument there.
Okay.
But Coinbase is going to benefit from Ripple's efforts up to this point on that issue, because they're going to have a game plan for how to proceed. So, you know, Coinbase, I don't think maybe off the top of my head has as good an argument, but they're going to have all of the work that Ripple's already done.
All right. Listen, I want to, you brought up a jury just now, Jeremy. You said that if you get in front of a jury such as Coinbase, and you made a point to tell the audience in the past that Ripple, in their summary judgment motions and their reply to the SEC summary judgment, they stated that the fair notice issue is a jury issue. And so what I want to do is, we're all right now waiting on Judge Torres's decision. Our friend Jimmy Filan, he said early on that he thought maybe by the end of March or around that time. He was spot on when it came to the Daubert motion. I've looked at previous rulings of her, and her decision has ranged from the same time as the Daubert motion to a couple months after the Daubert motion. So the first question is, do you think it could come down any day as far as her decision?
Yeah, well, to be truthful, I thought mid-March. So I'm already out of the running for accuracy here. So I think that, you know, I think Jim's prediction was based on, I guess, that 6-month rule, which since we were looking at it, I've looked at the actual rule, and it's a little bit different than what I thought it was. It's not like a motion is filed on a certain date and 6 months later there's a list of pending motions that haven't been ruled on yet. It looks like it's done a little bit differently. So I think, as far as, you know, March 15 or March 31, there's no hard time cutoff here. I think we're just going based upon what the judge has done in the past. And I think your research is probably the best, which, you know, on average, it's probably, you know, around a month or two after the Daubert motion, or in that range. But there's no hard and fast time cutoff. So it could come at any time, but it could come in April. It doesn't have to be in March.
And I got to tell you, I'm getting a little nervous, because, and I say nervous because you and I and others, you know, we've never said that Ripple's going to get an outright win or anything, but we've certainly poked holes at the SEC's case. I went on record to say I think that she's going to deny the SEC summary judgment as the way they've requested it. But now, just yesterday or today, Kathy Wood predicted a Ripple win from ARK Investment. She's a very smart woman, and you're seeing others now picking wins. And I always prefer the underdog role, Jeremy, to be honest with you. So I'm not gonna ask you, you know, a prediction, but I want to end with this jury question issue, because I've said that I think that we've underestimated the potential, because most securities cases are decided at summary judgment. The judge has the undisputed facts, but it seems to me, and you've tweeted this out, and I think you've rushed in the video, that there seems to be some disputed facts here. And so we have 3 basic elements in the Howey case. And the first one is, everybody knows, is an investment of money. Do you think that that is an issue that she could send to the jury because of the expert that was excluded? And what do you mean about that?
I don't think so. People could have different opinions. I don't think that would be the issue that would be sent out for a jury trial. I think I think those issues all could be decided by a judge. I mean, just for the viewers, you need a jury when you have to weigh this testimony and decide which one is more credible. And that's really what you need a jury for. And I don't think that the investment of money prong is the thing that will be sent to a jury.
Okay, what about the second factor is obviously the common enterprise, and it's something that you and I've poked holes at, and others have as well, of the SEC's theory. Do you think that there's enough for her to decide on common enterprise, or do you think that that could be a factor sent to a jury?
I don't think that's the one either. I think that the LRBY case is pretty clear, and we have 10, 12 judges in the past in the crypto space that we can look at that have made that decision based upon the facts in front of them. So I don't think that's the one either.
Okay, and then final, it's a two-pronged test. That's why some people call it a four-factor test and some people call it a three-factor. And the first prong of the third is a reasonable expectation of profit derived from the efforts of Ripple, basically. What about that factor? Is that one that you think could be teed up for a jury or no?
That's the one I think would be the one. If she's going to send it to a jury, I think that would be the one because of your work. We have a lot of we have affidavits that were submitted. We have counter facts from the SEC, not many, but there are some there. And so if I was the judge and I said, you know what, I'm not going to rule on this, this is going to go to a jury, this is probably the thing that I want the jury to rule on. What did an XRP purchaser back in 2017 think when he or she was buying XRP?
Okay. Now, and then obviously we talked about fair notice. Do you agree with Ripple that if she were to say that Ripple sold XRP as an investment contract in a certain period of time, do you think then it's a jury trial on whether Ripple had fair notice, or do you think the judge could summarily decide one way or the other that they did or didn't have fair notice?
It's a good question. I mean, Ripple obviously took a risk because they didn't argue fair notice other than to say it's an issue of fact for the jury to decide. I think let me just hedge my bets a little here. If the judge does send it to the jury, it'll be the SEC's fault because they brought in Larson and the other executive, I can't remember, Garlinghouse, I'm sorry. So, yeah, they brought in Garlinghouse and Larson, and
you conveniently forget the guy that can only revel your facial hair.
He's only the CEO, right? So anyway, because they brought him in, what the fair notice defense as to what they were thinking and when they were selling their XRP, I think lends itself to something that a jury could decide. And when you have a piece of the case going to trial, judges always think of judicial efficiency, right? So they're more likely to send the other piece, which is the Ripple piece, also to trial and say, you know what, since we're going to have a jury figure out what Larson and Garlinghouse were thinking about back in those days, we're also going to let's let them also figure out what Ripple was doing back in those days as well.
Which goes back to something that I think you and I agreed on very early in the case, which was charging the two executives in a non-fraud case was a very big mistake.
Absolutely. I'm with you on that. I think the SEC, if they could go back in time, I think would also probably want to undo that.
All right, and we're going to wrap up, Jeremy, but my final question, I guess, is are you surprised now that there hasn't been a settlement? And if you're surprised, do you attribute it to politics and agenda, or what do you attribute it to? Because I believe that if this case was about enforcing securities laws, it would have settled a long time ago. That's my personal opinion. So what do you think?
I thought the case would settle back in 2021, but I was naive. And as I kind of learned and looked at more cases that the SEC was involved in, I mean, all you have to do is look at this LRBY transcript hearing. And the SEC does not operate like a regular litigant. Obviously, it's not their money. They don't care. So it's not like when I litigate against an insurance company, that insurance company has to answer to its shareholders. Why did we spend $1 million fighting over a $10,000 case? They have to explain that. The SEC obviously doesn't have to explain why they're doing what they're doing to whomever. And so they don't operate like a regular litigant. And so the more I learned about the SEC, the more I realized that they have their own agenda, and they don't have to explain it to anyone. They operate kind of in a vacuum, and they're not answering to anyone. So I think that's a big problem. And obviously, Ripple went to SEC. This is not a surprise, and this is not a secret. Early on in the case, or even before the case was filed, and said, or I'm sorry, after the case was filed, and said, what can we do to make this go away? We want to IPO. We want to move forward with our business. What can we do to make this go away? And the SEC came back with something that Ripple just couldn't agree to. I have a feeling it had to do with registering every sale of XRP moving forward from that point. And Ripple's business model just can't support that, because you can't register every sale that you're going to make in a decentralized ledger. Just not going to work.
Yeah, so, I don't think the ODL platform warrants itself for registering every single sale to a customer who then ultimately might even sell it back to Ripple.
It defeats the purpose of the whole platform. So
absolutely. I'm not going to put you on the spot and ask you what everyone wants to know, which is, will there be another Legal Briefs video in the future? I just tell you that I know I'm back. I represent, as you know, 76,000 plus people. There's not many times I could say that I speak for all of them on a single issue, but I know I speak for them all when I say we want to see Legal Briefs back, at least an encore version, okay?
Well, listen, thanks so much for having me on, and I also appreciate everything you've been doing. I know how much work that is, so.
Well, thanks, Jeremy. All right. Be well, brother. I'll see you soon.
All right. Take care.
That is it for today. See you next week on the next version of Cryptolaw TV.